Hello friends, in the series on the income tax cases, today we will discuss the case of Union of India and others versus Baba Banda Singh Bahadur Education Trust. This case has been reported in 454 ITR at page number 273. The matter has been decided by Supreme Court and the date of the judgment is 26th April 2023. In this case, the issue before the Honorable Supreme Court was that if the assessee is earning consistently huge profits to an extent of 67% before depreciation and 44% after depreciation, then in that case, whether it can be said that whether the institution is solely for the purpose of education and whether it is eligible for granting registration under section 1023C clause 6. There is a word in section 1023C clause 6 that if an institution is wholly and solely for the purpose of, the main word is solely for the purpose of education, then it should be granted exemption. Since the assessee was earning huge profits to the extent of 67% before depreciation and 44% after depreciation, and the assessee has applied for the registration under section 1023C clause 6, the CIT exemption denied the registration by relying upon the judgment of Queen Education Society, which was given by the Uttarakhand High Court. The assessee went to the Punjab and Haryana High Court by filing the writ petition against the judgment of CIT exemption, and Punjab and Haryana High Court by relying on its own judgment, that is Pine Grove, allowed the exemption to the assessee. This was the background of this case. The department filed special leave petition before the Supreme Court against the judgment of Punjab and Haryana High Court, which gave the exemption to the assessee under section 1023C clause 6. The background of this case is that the department was relying upon the judgment of Queen Education Society and the assessee was relying upon the judgment of Pine Grove. The judgment on which the department was relying went to the Supreme Court for its review. The Supreme Court, in the judgment of Queen Education, set aside the judgment of Queen Society passed by the Uttarakhand High Court and confirmed the judgment of the Pine Grove. So, up to this situation, this case should go in favor of the assessee. But after the judgment of Queen Education by the Supreme Court, the new judgment of the Supreme Court came in the case of New Noble Education Society. In that case, the Supreme Court reversed its earlier judgment in the case of Queen Education Society and said that the law laid down in the Queen Education Society, which was defining the purpose of the education, and the word solely, the solely word was not defined properly, and the Supreme Court in its latest judgment, that is New Noble Education Society, reversed its earlier judgment in the case of Queen Education Society and said that the judgment of Queen Education Society was correct and Pine Grove was not correct. The meaning thereby that the Supreme Court in its latest judgment, which was a 3-judge bench judgment, reversed its own earlier judgment and by relying on the judgment of New Global decided the present appeal against the assessee and in favor of the department. The crux of the theory is that It was the viewpoint of the Supreme Court in the latest judgment of New Global that the definition of the word solely is very restricted. It should not be stretched. And if the assessee is earning huge profits, then it cannot be said that it is existing solely for the purposes of education, and the exemption to the assessee under section 1023C clause 6 should not be given to the assessee. Friends, at the face it seems to be a very technical judgment, because in this case the earlier judgments were reversed and the new law came. But the crux of the theory is that if any education society is earning profits to a very big magnitude, then in future there are very less chances that they can get their exemption persistently or consistently. At the end of this video, once again I am repeating the name of the case. The name of the case is Union of India and others versus Banda Singh Bahadur Education Trust, and this case has been reported in 454 ITR, page number 273. The matter has been decided by Supreme Court and the date of the judgment is 26th April 2023. Thank you, friends.